Good afternoon. May it please the court, I'm Janet Hayes from the Knoxville Bar, and I'm here today on behalf of the appellants, and I will collectively refer to all of the appellants as applied. I would like to reserve 3 minutes for rebuttal, if that's permissible.
All right.
As the court is aware, this case has an extensive procedural history. The underlying dispute centers on Applied's attempt to recover payments that Mylan owes for its participation in a workers' compensation insurance program. The issue on appeal, however, is far more narrow than that. This appeal centers on the Chancery Court's subject matter jurisdiction and, quite simply, Applied's quest to be heard in the Chancery Court. While most of the procedural history has no bearing on the issues before the court, there are 3 significant events that I think inform our arguments today. The first is what I would characterize as the Nebraska litigation. Pending since 2016, this is Applied's lawsuit seeking to recover the payments that Mylan owes for its participation in the insurance program and the benefits that it received. As part of that litigation, Mylan has filed a counterclaim and seeks to avoid payments and has asserted various legal theories against Applied. For that counterclaim, Mylan needs assistance from the Tennessee Department of Commerce and Insurance. I would argue that counterclaim is the root of why we are here today. The second significant procedural event is what I will characterize as the department's regulatory action. In 2019, after Mylan and Applied had been litigating for 6 years, Mylan lodged a complaint against Applied for the first time with the Tennessee Department of Commerce and Insurance. Importantly, based on that complaint, the department filed charges against Applied, conducted extensive investigation into Applied and the program at issue, gathered significant discovery, and prosecuted Applied for well over a year before ultimately dropping those charges. However, Mylan continued to need the assistance of the department and has now returned, this time asking the department to issue a declaratory order. Importantly, in its petition for declaratory order, Mylan alleged the exact same allegations against Applied that the department had alleged back when it was prosecuting Applied in the regulatory action. Essentially, Mylan did a cut and paste of the petition. To be clear, Mylan is now asking the department to serve as the adjudicator and issue a declaratory order in a matter based on the exact same allegations that the department previously prosecuted and against the exact same party that the department previously prosecuted. Applied moved to dismiss the allegations or the petition in the department. It was denied. And I should say, the department convened a contested case hearing, though we will argue later that did not occur within the 60 days required by statute. But Applied sought to have that dismissed. It was denied. Applied then filed a petition for interlocutory judicial review with the Chancery Court. The issue before this court is whether the Chancery Court should have subject matter jurisdiction, since future review of a final agency decision would be an inadequate remedy. Now, because this matter involves subject matter jurisdiction, there is a preliminary, but I would argue determinative issue that this court must address. As the court is very well aware, when a movement challenges subject matter jurisdiction, the movement must choose either a facial challenge or a factual challenge. A facial challenge is one which tests the legal sufficiency of the complaint. It has been likened in the case law to a motion to dismiss. It declares war on the complaint. A factual challenge, on the other hand, tests the legal sufficiency of the evidence and demands that the court weigh evidence. In order to create a factual challenge, this court has said that the movement or the challenger must create a genuine issue of material fact. To be clear, it was the department's burden to controvert the facts if the department wanted to create a factual challenge. They did not. The department's motion and the department's arguments up until the eve of hearing were all based on a facial challenge. And again, the overarching distinction is whether the department created a genuine issue of material fact, whether the department controverted the facts. And I would like to point to a few factors that indicate the department did not. The first I would ask the court to look at is simply the timing of the motion. The department filed its motion challenging jurisdiction right after Applied filed its petition seeking review. Importantly, they filed their motion before filing an answer. So the question I ask is, how did they controvert the facts? They had not even filed an answer. And while not controlling, there is authority from the Third Circuit that specifically describes a factual challenge as one filed any time, and I quote, after an answer has been filed. That case drops a footnote and the court explains the law that Tennessee follows, which is a factual jurisdictional proceeding cannot occur until plaintiff's allegations have been controverted. In this case, with the pre-answer motion, the department did not controvert the facts. They created a facial challenge. But that's just one factor I would ask the court to look at. I would also, and perhaps more importantly, ask that you look at the substance of the challenge itself. Look closely at the language the department chose and used. The department's motion itself alleges there is, and I quote, no legal basis for jurisdiction. Had the department intended to make a factual challenge, they would have said the facts don't support jurisdiction. The department's own words go on to say that the petition, quote, fails to state a claim. Again, that language is hallmark of a facial challenge. I think most telling is the department's language where they said there is no jurisdiction because of, quote, legally insufficient allegations in the petition. That is almost by definition a facial challenge. It is challenging the allegations in the petition. Had the department intended to make a factual challenge, it would have pointed to the facts that it disagreed with, not challenged legal conclusions drawn from the facts, but would have challenged facts. Here, the department only challenged the allegations in the petition. Another indicator that this is a facial challenge is the department's failure to present any evidence. Most of the case law suggests you look at declarations or affidavits or whatever evidence the challenger presented. Here, the department presented nothing. And even more telling, it's the department's duty to file the administrative record before the trial court, and the department sought and received permission to delay filing the administrative record, thereby suggesting to me they wanted the Chancery Court to rule on jurisdiction based on the complaint without receiving all of the evidence that would be contained in the administrative record. Now, the department will argue, and has argued in their brief, that it was really a facial challenge because they relied on the evidence that Applied attached to their petition. But I would really encourage this court to look closely at the challenge below. The only citation to any evidence was one lone citation to a signature line that is immaterial to the issues on review, and it's a fact we do not disagree with. Otherwise, there is nothing in their motion that points to any evidence, yet they asked this court to say that it was a factual challenge weighing the sufficiency of the evidence. Also, at the 11th hour, in their reply brief before the trial court, the department tried to retroactively characterize their challenge as a factual challenge. And again, it did nothing but change the label. They still didn't point to any facts or controvert any facts or submit any evidence. They simply relabeled what was the exact same substance. And they also did it on the eve of the hearing before leaving Applied no opportunity to adequately respond to it when the entire time it had been a facial challenge. So although the department's challenge was very clearly a facial challenge, the trial court conducted a factual challenge review. And I think both the department and Milan have conceded that in their briefs. I would argue that the trial court order actually went a little further and started addressing the merits of the case in addition to the factual challenge review. I think it is also very important to note that Milan has admitted that under a facial challenge review, the Chancery Court has subject matter jurisdiction. I would point to page 2 of their reply in the trial court, where they said, the petition, our Applied's petition for judicial review, alleges facts that, if true, would bring the case within the court's subject matter jurisdiction. And so as we stand here today, I say they did not and have not challenged those facts. The trial court should have conducted a facial challenge review, and had it done so, jurisdiction would be established. But moving forward, even if the trial court, if this court somehow concluded that it was a factual challenge or that the trial court correctly did a factual challenge review, I would still urge this court to reverse the trial court. The test is whether future review of the final agency decision would be an adequate remedy. Here, it would not. Applied has alleged a violation of due process, and I think the facts and procedural background I have articulated explain the due process violation. In Sizemore, the Tennessee Supreme Court said due process demands a relatively level playing field in a contested case hearing. Here, Applied does not have a relatively level playing field. We're being asked to adjudicate before the very tribunal that prosecuted Applied previously on the same allegations. The standard is not whether Applied suffered actual bias, but whether that created an intolerably high risk of bias. And we would argue there was an intolerably high risk of bias. Therefore, we had an injury, a due process injury that was effective immediately and cannot be effectively addressed on future review of the final order. I see I'm out of time. I will defer.
Good afternoon, Your Honors. My name is Pablo Varela from the Attorney General's Office on behalf of the Department of Commerce and Insurance. We are splitting time with Milan. We ask that 3 minutes be allotted to Milan and 12 minutes be allotted to the department.
Got that. Okay, go ahead.
This court should affirm the lower court's dismissal of the interlocutory petition for judicial review because the court lacks subject matter jurisdiction under 45322A1. The court lacks subject matter jurisdiction because petitioners failed to show the court that review of a final agency decision in this case would not provide them with an adequate remedy. And in fact, review of a final agency decision in this case would provide them with an adequate remedy. As Your Honors heard, after the administrative law judge dismissed the petition for judicial review, petitioners applied to the Chancery Court for interlocutory appeal, raising two interlocutory issues. First, the department lost jurisdiction for not setting a contested case hearing within 60 days under TCA 45223C. And second, that the contested case proceedings violate the petitioner's procedural due process rights for an alleged impermissible risk of bias theory. The department moved to dismiss that petition, challenging the court's subject matter jurisdiction. I'd like to address briefly the issue of whether the department raised a facial or factual challenge to the court's subject matter jurisdiction. As this court noted in the Excalibur case that is cited throughout all our briefs, it is not the form of the briefs that dictates whether or not a facial or factual challenge is raised, but it is the substance of the arguments alleged. Here, the department made a factual challenge to the court's subject matter jurisdiction, attacking the sufficiency of the facts the petitioners used serving for basis for jurisdiction in this case. The department argued that when the facts alleged by the petitioners are compared to the facts of the 2021 charges in the proceedings and the facts in the proceedings of the case below, and in addition, the procedural department rules of the Administrative Procedures Department, the petitioners failed to show that review of a final agency decision would not provide them with an adequate remedy. Specifically, the department cited to APD Rule 1360-04-01-.05 to show that the department, in fact, did set a contested case hearing within 60 days under TCA 45322-223C. And second, the department cited to the facts that the petitioners put and attached to their record, showing that the alleged procedural due process violation based on the intolerable risk of bias didn't exist in this case. Petitions for judicial review are governed by TCA 45322A1, which permits appeals from agency decisions in two cases. One, on a final decision, which is the general rule. It's not the case here. And second, on an interlocutory basis, but only if review of a final agency decision can be shown to not provide an adequate remedy on appeal. Petitioners had the burden to show that, to establish that the lower court had subject matter jurisdiction over its petition, and therefore had to show the court that review of final agency decision would not provide an adequate remedy on appeal, but they failed to do so. When a court looks at what would provide adequate remedy on appeal, they have looked at various factors, including but not limited to irreparable injury if immediate appeal is not granted, or in some cases, the risk of retrial. The lower court addressed both in its order. Considering the irreparable injury argument, the lower court noted that it is an example of, but not entirely the standard for determining whether a review of a final agency decision would not provide an adequate remedy on appeal. This court in George Nikopoulos, MD versus the State of Tennessee Board of Medical Examiners cautioned that enjoining administrative proceedings prior to the exhaustion of administrative remedies is not favored unless it can be shown that an irreparable injury would result. As opposed to arguing for damages that are merely speculative based on nothing more than a fear that the administrative decision below would be prejudicial. Here, as the lower court noted, the petitioners failed to show any irreparable harm as opposed to just merely speculative damages based on nothing more than an apprehension that the administrative proceedings below would be prejudicial. Petitioners have not alleged any facts showing that an injury could not be redressed on review of a final agency decision. The only injury petitioners allege is the supposed risk of retrial for both claims that they have raised. But that risk of retrial is speculative for two reasons. First, it assumes that there will be an adverse ruling by the department against the petitioners. And second, it assumes that that ruling will be based on some sort of error. In considering the risk of retrial, the lower court balanced the risk with the obvious potential that the department rules in favor of the petitioners, thereby resulting in no risk of retrial. But the risk of retrial alone is does not establish that review of a final agency decision would not provide an adequate remedy on appeal. Petitioners rely on the Excalibur case to suggest that the risk of retrial in this case was sufficient to grant the lower court subject matter jurisdiction on an interlocutory basis, but their reliance on Excalibur is misguided and misplaced. That case is easily distinguishable here, and the ruling in that case was also limited to the facts of the case. Excalibur involved the denial of a motion for discovery in the administrative proceedings, which resulted in a unique situation where potentially relevant evidence was excluded from the record on appeal of a final agency decision. According to the court in Excalibur, the risk of retrial was Excalibur's most persuasive argument in that case for jurisdiction because the discovery issue would have affected the Chancery Court's ability to conduct a full and faithful review on the substantial material evidence standard on appeal. Therefore, the court's chief concern was, did the Chancery Court have a complete record to review on a final agency decision? But the concerns in Excalibur are not present here. There is no issue concerning completeness of the record. The facts concerning both issues raised by the petitioners, the 60-day setting issue and the procedural due process claim, are contained in the record. They were fully briefed by the parties and adjudicated by the administrative law judge below, providing the Chancery Court a complete record for review on a final decision. Under TCA 45322 as well, petitioners are permitted to raise constitutional, statutory, or procedural violations upon a final order of the department. And 322H provides the reviewing court broad latitude in fashioning adequate relief upon that review. Therefore, that would provide petitioners an adequate remedy. The court reviewing the case could affirm, remand for additional proceedings, or even modify the agency decision on final review. What petitioners are asking this court to do is expand the holding in Excalibur. In fact, if petitioner's interpretation of Excalibur and its application prevails here, it would eviscerate the default rule requiring a final order before a judicial review of an agency decision, and it would also subsume the general rule into the exception for interlocutory review. In other words, petitioner's interpretation would result in every motion to dismiss, every procedural motion, every summary judgment motion, every pretrial motion at the administrative level being immediately appealable to the Chancery Court on an interlocutory basis. But expanding Excalibur is not warranted by the facts in Excalibur or its holding, and it's not warranted by the facts in this case. Petitioners argue that review of the final agency decision wouldn't provide them an adequate remedy because of an alleged procedural due process violation on an impermissible risk of bias theory. Petitioners noted that in 2019, Mylan filed charges against the petitioners, and the department brought charges against them on those facts. Ultimately, the department dismissed those charges without prejudice before any hearing, before any determination of the merits of that case. After the department dismissed those charges, Mylan filed the instant petition for declaratory order below on similar facts. But the petitioners allege that because the department simply switched roles from prosecutor in the 2021 charges and adjudicator for Mylan's petition below, that somehow that has created an impermissible risk of bias, that the department has prejudged Mylan's petition for declaratory order. But simply alleging that the department switched roles is not sufficient to show a procedural due process violation. This court in Sizemore addressed procedural due process violations in the administrative context. The court noted that the prevailing view is that just identifying that a department has different roles is not sufficient to raise or allege a procedural due process claim. What a party must show is the risk of actual bias is intolerably high. And in the case where you're talking about a department's prosecutorial and adjudicative functions, which is the case in here, the Sizemore court said the only time that the risk of bias becomes intolerably high is when the same attorney acts as both prosecutor and adjudicator in the same or similar proceedings. But that is not the case here. Petitioners have not alleged that the attorneys that prosecuted the 2021 charges is the same attorney advising the commissioner in the case below. In fact, the department did cite to facts that petitioners attached to the record showing that one, the proceedings were not the same. The parties were different. In the 2021 charges, the department was a party against the petitioners. In this case, it's a petition for declaratory order filed by Mylan Express Company. In addition, the relief sought by the two proceedings was different against the petitioner. Second, the department pointed to facts in the record and attached to the petition that showed that the attorney prosecuting the 2021 charges was a different attorney than the attorney that is advising the commissioner on the petition for declaratory order below. And finally, the department showed that the administrative law judges that were sitting in conjunction with the department in the 2021 charges was not the same judge that is sitting in conjunction with the department below. As a result, the petitioners have failed to show an intolerable risk of bias, or any bias, in fact, on the part of the department that would show that review of a final agency decision in this matter would not provide them with an adequate remedy on appeal as to their procedural due process claims. Because the petitioners failed to show that review of a final agency decision in this matter would not provide them with an adequate remedy, this court must uphold the lower court's dismissal of the interlocutory petition for judicial review and remand the matter to the department for further proceedings. Unless the court has any questions.
See none. Thank you.
I'll use my time.
Good afternoon. I'm Scott Carey, counsel for the co-appellee Mylan Express. In my 3 minutes, I plan to focus on the issues which are most relevant to my client rather than repeating the arguments that have been so ably made by the Attorney General. And the issue that's most important to Mylan is putting an end to this litigation nightmare. When it purchased workers' comp insurance from Applied in 2008, this small family-owned trucking company based in Milan, Tennessee, not too far from Dyersburg, never envisioned that it would be here in 2025. So far, we've been in 8 different forums. We're now in the 13th year of litigation. In fact, my co-counsel from Baker Donaldson, who are now assisting me, were actually in middle school when this saga began. At every turn, Applied has raised procedural issues to delay getting to the merits, and it is now taking the absurd position that no court or tribunal can adjudicate Mylan's claims. The underlying dispute stems from Mylan's purchase of insurance, which required it to sign a reinsurance participation agreement, or RPA, with a 3-year term. Applied did not seek or obtain permission from the Department of Commerce and Insurance to sell that insurance product in Tennessee as required by law. And with only a few months left in that insurance policy, Mylan's premiums doubled, and with no explanation, Applied claimed that Mylan owed it an additional $3 million. Since then, Applied has used the system to delay and discovery and a hearing on the merits. There's been no written discovery, and Mylan has not been allowed to depose any of the Applied witnesses or even obtain information on the status of this protected cell that hopefully still holds Mylan's money. Instead, Applied has manufactured arguments to shield itself from scrutiny. First, it spent years, multiple years, trying to enforce an arbitration clause in the RPA that was on its face unenforceable by statute. And then it went to the Nebraska State Court and argued in a motion to dismiss that the primary jurisdiction doctrine made the Tennessee Department the sole jurisdiction to make factual findings regarding the enforceability of the RPA. So the Nebraska court agreed and stayed that case until the parties obtained an administrative ruling on the RPA. And that's the most important point I want to make this afternoon, is that Mylan filed its petition for declaratory judgment with the Tennessee Department of Commerce and Insurance after Applied had successfully argued to that Nebraska State Court that the department was the entity that must answer these fundamental questions. But now Applied is here arguing to this court that the department does not have jurisdiction. Applied can't have it both ways. We need the department to resolve these issues. In closing, we simply ask that Mylan has been asking for 13 years to try to get to the merits. We respectfully request that you deny this appeal and allow us to finally proceed on the merits. Thank you.
Thank you.
If I may start with Mr. Carey's point, no one would love to end this, I think what he called judicial nightmare, any more than Applied. In fact, it is Mylan that continues to come to the department not seeking one bite at the apple, but now seeking 2 bites at the apple and continuing to protract and delay instead of paying the payments that are owed in the underlying case. A couple of points I would like to make in response. I would ask the court to consider, based on the arguments that you just heard and I just heard, where is the factual challenge that warrants a factual review? No one has disputed any of the underlying facts. You did not hear today any arguments that highlighted any factual disagreements. The parties agree on the facts, and the department made a facial challenge to subject matter jurisdiction, not a factual challenge. I think what you heard was telling, but what you didn't hear is more telling. Everything that's said is indicative of a facial challenge, and to the extent it wasn't, I think what you heard argued were legal conclusions that were the merits. And if the merits are so intertwined with the question of jurisdiction, then it is the law that jurisdiction should be established and Applied should be heard on the merits. I don't think that the department can have it both ways. Also, I wholly disagree with the point that we are asking for an expansion of the law. We are not at all asking for an expansion of the law. And in fact, I think this case, I'm hesitant to say that it is a question of first impression, but I can say we have researched it thoroughly and cannot find a case with this same procedural background. And if I may try to just sharpen the point that I'm making, that an agency only has the authority that's granted to it by statute or regulation. The department under its regulatory authority, is able to prosecute and adjudicate and investigate. And in that capacity, there certainly are some overlapping roles. And you will note that back in the 2019 regulatory action, we did not claim a loss of due process because the statute contemplates that in its capacity as a regulator, there may be some overlapping functions. And in order, if you look at the case law, there is a due process violation when the same person, in the one case mentioned, the same individual sits as a prosecutor and an advisor to the commissioner. But that's all within the confines of the regulatory proceeding. Here, Milan has come back. When they didn't get what they needed in the regulatory proceeding, they came back. And now they seek the department's authority, its adjudicative authority under the Uniform Administrative Procedures Act, a wholly different set of authority. The Uniform Administrative Procedures Act only authorizes the department to issue declaratory orders, to serve as an adjudicator. It contemplates a singular role, not a role as prosecutor, which is what we have happening here. As I'm out of time, I would just ask the court to, for further arguments, please review our brief, and we would ask that the Chancery Court be remanded and that we simply have an opportunity to be heard in the Chancery Court. Thank you.
Thank you, counsel. We will take this matter under review the record, and provide you with an opinion at the earliest possible date. You may be excused.